Dear students, I'm Sahir Gul and I welcome you all to this lecture. Today's topic for discussion is meetings. The main aim of this lecture is to develop an in-depth understanding of different types of meetings, the various facets and conditions necessary for the formation of different types of meetings that can be established in India under Company Act of 2013. After reading this lesson, you should be able to A. Know about the various types of meetings under the Companies Act of 2013. B. Understand the importance of these meetings in running a company. C. List the persons authorized for convening company meetings. Dear students, in this segment, we'll try to enhance our understanding of meetings by extensively looking at different types of meetings recognized under the Companies Act of 2013. This will be elaborated by the structure drawn by the company law necessary for holding of meetings by companies in India. Meaning and definition of company meeting. The word meeting is not defined anywhere in the Companies Act. Ordinarily, a company may be defined as gathering, assembling or coming together of two or more persons by previous notice or by mutual agreement for discussion and transaction of some lawful business. Some important definitions of meeting are given below. In the case of Sharp versus Davis, 1971, the meeting is defined as an assembly of people for a lawful purpose or the coming together of at least two persons for any lawful purpose. According to P.K. Ghosh, any gathering, assembly or coming together of two or more persons for the transaction of some lawful business of common concern is called meeting. According to K. Kishore, a concurrence of coming together of at least a quorum of members by previous notice or mutual agreement for transaction business for a common interest is meeting. From the definition of meeting, it can be concluded that meeting is the congregation of several persons in a particular place for the purpose of discussing some important matters and expressing their opinion on the questions raised. As we have already discussed the important definitions of meeting, now let's consider the requisites of valid meeting. A meeting should be conveyed by a proper authority. It must be conveyed by a proper notice served in the prescribed manner to all persons entitled to receive such notice. It must be conveyed to transact lawful business as per its agenda. It must be presided by properly elected chairperson. It must have a proper quorum. It must be conducted by following lawful procedure. Proper resolutions must be passed for transacting business of the meeting. The minutes of the proceeding must be properly recorded. So now we have identified the first aspect of meetings. Now let's turn to the second important aspect of meetings, which is kinds of company meetings. The meetings of a company may be classified into the categories. Meeting of shareholders, annual general meeting, extraordinary general meetings, class meeting of shareholders/members, meeting of directors, meeting of board of directors, meeting of committee of directors, other meetings, meeting of debenture holders, meeting of creditors, meeting of contributors. Meeting of shareholders. The shareholders are the real owners of the company, but due to certain limitations, they cannot take part in the management of the company. They leave this to their representatives called the directors. For controlling the board of directors and their activities, shareholder meetings are held from time to time. Meeting of shareholders can be classified annual general meeting, AGM. AGM is defined under section 96 of Companies Act 2013, where every company, whether public or private except one person company, is required to convene first AGM within 9 months from the end of first financial year to decide the overall progress of the company as well as to plan future courses of action. Annual general meeting is a regular meeting of the members of company which is held annually. This meeting provides an opportunity to the members of the company to review working of the company and express their views on the management of the company. The object of holding this meeting is to review the progress and prospects of the company and elect its office bearer for the coming year. Holding of the meeting. The first annual general meeting of the company is held within 18 months of its incorporation. After holding such meeting, it is not necessary to hold any other annual general meeting in the year of its incorporation and in the next year subsequent. Annual general meeting must be held by company each year within 6 months of the closing of the financial year. The interval between any two annual general meetings must not be more than 15 months. The registrar is empowered to extend the time up to a period of 3 months, except in the case of first annual general meeting. Place of meeting. Such meeting is called at the registered office of the company or any other such place in the city where such registered office is situated. Notice. The board of directors has to call annual general meeting giving 21 days of notice to all members entitled to attend the meeting. However, such a meeting may be called with shorter notice if it is agreed to by all members to vote in the meeting. Certified copies of profit and loss account and balance sheet, director's report and auditor's report should be forwarded to the members at least 21 days before the holding of the meeting of the company. Considering the importance of annual general meeting to shareholder, it has been held that the directors must call the meeting even though the accounts are not ready or the company is not functioning. Statement of the business to be transacted at AGM. Every notice of an annual general meeting shall contain a statement of the business to be transacted at such meeting. The statement of business to be transacted at an annual general meeting shall essentially contain the 4 items of ordinary business. These are, first, the consideration of financial statements and the reports of the board of directors and auditors. Second, the declaration of dividends. Third, the appointment of directors in place of those who are retiring. Fourth, the appointment for fixing of remuneration of auditors of the company. Moreover, if the company intends to transact any item of special business, those items of business shall also be described under the head Special Businesses. The special businesses should be included in the notice and an explanatory statement of material facts as to each of those items shall be annexed with the notice of the annual general meeting. Quorum. A minimum of 5 members personally present and entitled to vote in the case of public company and 2 members personally present and entitled to vote in the case of private company shall be the quorum for a general meeting. Extraordinary general meetings, EGM. Certain matters are so much important that they require an immediate attention of the members, and that is where the board has been granted to call for such EGM under Section 100 of the Companies Act. This meeting be called to discuss, first, alteration of the clause of Memorandum of Association, or second, changes in the Articles of Association, or third, scheme of the reduction of share capital, etc. EGM can be called through, first, board on suo motu basis, and the same can be held at any part of the country by requisition of eligible members, wherein the company having share capital, then members holding at least 1/10 of the share capital, and if not having share capital, then members holding at least 10% of the total voting powers in that company can request to call for such meeting. Such notice has to be well written and specify the nature of the business, and duly signed by all members or any one authorized person acting on behalf of all. And the board needs to call meeting within 21 days of getting such request, or maximum of 45 days, by giving such notice to such members prior to 3 days of conducting such meeting. By requisitionist, provided if board fails to do so, if board fails to conduct the meeting within 45 days, then the members can call for meeting within 3 months from the original request made to the board. At first instance, and here the members have all rights to have their name on the main list of members, and board can't deny this, and also need to accept such changes that might have occurred between 21st to 45th day of date of notice provided to board at first instance. By tribunal under Section 98 of Companies Act, whereby it can conduct meeting on its own or on any request received by the member of such company. Notice of EGM. Provisions regarding notice of EGM are the same as in the case of any other general meeting of a company. A brief statement of these provisions are: First, an extraordinary general meeting may be called by giving at least 21 days of clear notice. Second, such a meeting may be called by giving a shorter notice that's specified if consent is given in writing from electronic mode by not less than 95% of the paid up share capital of the members entitled to vote at such meeting of the company. Third, notice must be in writing. Section 4, it must state the place, day and hour of the meeting. Section 5, it must contain a statement of special business because at an extraordinary general meeting only special business may be transacted. Class meeting of shareholders. Class meetings are meetings which are held by the holders of a particular class of shareholders. For example, preference shareholders. Such meetings are normally called when it is proposed to vary the rights of that particular class of shares. At such meetings, these members discuss the pros and cons of the proposal and vote accordingly. Class meetings are held to pass resolutions which will bind only the members of the class concerned, and only members of that class can vote and attend. Such meeting is convened by a particular class of shareholders only, and only if they think that their rights are being altered or if they want to vary, they attach their rights as mentioned under Section 48 of Companies Act and under Section 232 also. If under mergers and amalgamation scheme, meetings of particular shareholders and creditors can be conveyed if their rights privileges are being varied to their interest in such company. Meeting of directors. Meeting of board of directors. Directors collectively are called the board of directors. Therefore, any meeting of directors of a company is called the meeting of the board of directors. As per Section 173 of the Companies Act 2013, every company needs to convene a first board meeting within 30 days of its incorporation, and then minimum 4 meetings in each calendar year, with time gap of not more than 120 days between 2 board meetings. In other words, no 3 months should pass without directors' meeting being held, and no year should expire without at least 4 directors' meetings having been held in it. The object of this section is to ensure that the board meetings are held at reasonably frequent intervals so that the directors may be in touch with the management of the affairs of the company. However, the central government is empowered to relax the rule with regard to any class of companies. Section 285. The object of this provision is to save smaller companies having insufficient business to be transacted at board meetings from unnecessary hardship and expenditure involving in holding them. Board meetings are called for the following businesses: to issue shares and debentures, to make call on shares, to forfeit the share, to transfer the share, to fix the rate of dividend, to take loan in addition to debentures, to invest the wealth of the company, to think over the difficulties of the company, to determine the policies of the company. Quorum: 1/3 of total directors or 2 directors, whichever is higher. Meeting of Committee of Directors. Under Section 177 of Companies Act 2013, Board of Directors may delegate certain matters to the committee set up for the purpose. Committees are formed as means to improve board effectiveness and efficiency in areas where more focused, specialized and technically oriented discussion is required. The Board of Directors may form certain committees and delegate some of its power to them. These committees should consist of only directors. The delegation of powers to such committees is to be authorized by the Articles of Association and should be subject to the provisions of the Companies Act. In a large company, routine matters like allotment, transfer, finance are handled by subcommittees of the Board of Directors. The meetings of such committees are held in the same way as those of board meetings. For instance, Audit Committee, Nomination and Remuneration Committee, Corporate Social Responsibility Committee, etc. Other meetings. Meeting of debenture holders. A debenture is kind of a document acknowledging the money borrowed, containing the terms and conditions of the loan, payment of interest, redemption of the loan, the security offered, if any, by the company. Debenture holder does not have the right to vote in the company's general meetings of shareholders, but they may have separate meetings to vote. When a company issues secured debentures, it executes a trust deed. The deed empowers the debenture holders to hold meetings and to pass resolutions to vary their rights in certain cases. All matters relating to holding, conduct and proceedings of meeting are given the trust deed. The decisions arrived at such meeting with requisite majority are binding to all debenture holders. Meeting of creditors. every person having a pecuniary claim against the company, whether actual or contingent, is a creditor. In general, any person having pecuniary claim against the company capable of estimate is a creditor. The meetings of creditors are called when the company proposes to make a scheme for arrangement with its creditor. Meeting of creditors is a term used to denote a meeting set up by the company to formulate a scheme for arrangement with its creditors. The Companies Act 2013 not only gives power to the company to negotiate with the creditors but also lays down the process of doing so. Section 391 to 393 of Companies Act not only gives powers to the company to compromise with the creditors but also lay down the procedure of doing so. Meeting of contributories. The member of the company on the commencement of the business are known as contributories. As per Section 428 of the Companies Act 2013, every person who is liable to contribute to the assets of the company at the time of its winding up or holder of a full paid share is called a contributory meeting of contributors, in a term used to denote a meeting set up by the company to formulate a scheme for arrangement with its contributories. Now that we have a good understanding of the concept of meeting and the important types of meetings, we need to move forward and understand the concept of one-man meetings for further clarity on the topic. One-man meeting. To convene a meeting, two or more persons must be present. A meeting cannot be constituted by one person. However, there are certain circumstances where one person can constitute a valid meeting. They are meeting convened by central government. Where the central government calls an annual general meeting under Section 167 of the Companies Act, it may direct that one member of the company present in person or by proxy shall constitute the meeting. Absence of quorum in an adjourned meeting. By quorum, we mean the minimum number of the members who must be present at a meeting as required by the rules. In the absence of quorum, the proceedings of company cannot be started. If the quorum does not complete within half an hour of the prescribed time, meeting will be adjourned to the same time, place and date in the next week. If at the adjourned meeting also the quorum does not complete, the members present shall be quorum, and attending members, even if one member is present, may be allowed to come to a decision and pass resolutions. It means one member present in person shall constitute a valid meeting. Meeting conveyed by Company Law Board. Where the Company Law Board calls a meeting under Section 186 of the Act, other than annual general meeting, it may direct that one member present in a person or proxy shall be deemed to constitute a valid meeting. Class meeting of shareholders. Where one person held all shares of a particular class, that member alone was held to constitute a valid meeting of that class of shareholders. Meeting of one-man committee of board of directors. The board of directors may delegate their work to a committee, which may have only one member. When the meeting of such committee will be held, only one member will be present and he alone will constitute a valid meeting. In addition to this, let's discuss some of the advantages of meetings. It helps in developing better solutions than any one individual can do. It provides free interchange of ideas, thereby stimulating and clarifying thinking. Group decisions promote effective coordination of subsequent action plans. The biggest merit is that meetings help in building good working relationship. Dear students, I hope you have developed a wholesome understanding of meetings, their definition, characteristics, and different types established under the company law and recognized by the Companies Act 2013. With this, we conclude our today's lecture and I hope you enjoyed this lecture. I wish all of you good luck.